Here we'll start another act relating to Hindu law, and that is Hindu Succession Act 1956. So, before starting the act, we will deal with the provisions as it was laid down in the traditional Hindu law. So, let us go to the introduction portion of that. As the system of inheritance among the Hindus was governed by the Mitakshara system and by Dayabhaga system or the Mitakshara school and the Dayabhaga schools, which in long generated inequalities and injustices. To remove these revolutionary changes were brought under the present Act, and that is Hindu Succession Act 1956. But the schools are based upon the text of Manu, while in the Mitakshara system, the guiding principle is the rule of consanguinity. In the Dayabhaga system, it is the doctrine of religious efficacy. Mitakshara system recognizes the devolution of property by survivorship and by succession. Dayabhaga system recognizes devolution of property only by succession. Only by succession, no survivorship. It does not recognize devolution by survivorship nor a distinction between joint family property and self-acquired property or separate property. The doctrine of religious efficacy of the Dayabhaga school says devolution of property by succession is on the competency of a person to offer oblation and to perform funeral rites. So, these are the very traditional laws relating to Hindu succession of properties, and as provided by the Mitakshara system and the Dayabhaga system. But the present act of Hindu Succession Act 1956 came into force on 17 June 1956. It deals with the intest succession. The very object is to create a uniform system of law of succession for all sections of Hindus to meet the needs of a progressive society. So, the present act as provides four categories of persons on whom the order of succession to the property of an intest person devolves, and they are heirs in class 1, heirs in class 2, the agnates and the cognates. So, the heirs in class 1 of the schedule, heirs in class 2 of the schedule, the agnates and the cognates, the 12 heirs in class 1 inherit the property simultaneously and an equal share But in class 2, agnates and cognates, the rule of preference is preferred. Besides a uniform order of succession, the other important innovative provisions that we found under this act are uniform order of succession, absolute ownership of Hindu women's right to property, and it also recognizes right of a child in womb over the property. So also it removed all the disqualifications those were mentioned in the traditional Hindu law. So also it recognized the right of illegitimate children over the property. So regarding that, we'll discuss certain definitions, and such definitions are provided under section 3 and subsection 1. So before discussing those definitions, we must again deal these innovative provisions in the act. So besides a uniform order of succession, the important innovative provisions are the absolute ownership of Hindu women's right to property, so also the right of the child in womb at the intest's death and subsequently born alive, so also removal of the disqualifications mentioned in the old law, as for example, physical defects, deformity, on or diseases, and the right of illegitimate children to inherit the property of their mother is also being recognized under the present act, and as per the definitions under subsection 1 of section 3, first we will deal the definition regarding heir, then intest, then related, then agnate, then cognates, full blood, half blood, uterine and blood, and Alisantana law, Maru Makatayam law, so also Namrudilla. So regarding the heir, as it is defined under subsection 1 of section 3, any person, male or female, who is entitled to succeed the property of an intest. And regarding intest, it is defined as a person who had not made a testamentary disposition of his property. And regarding the definition of related, legitimate kinship, and kinship is created by blood or by adoption with lawful marriage. And as regarding agnate, it means a person related to wholly through males, either by blood or by adoption. And regarding cognate, it means a person related not wholly through male but through females, like sons, daughters, sons, daughters, daughter, sister's son or daughter, mother's brother, son, or cognates. And regarding full blood, it as defined, two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife, and regarding half-blood, two persons when descended from a common ancestor but by different wives, then they are considered as half-blood. And regarding uterine blood, two persons when related to each other by uterine blood when they are descended from a common ancestor but by different husbands. And regarding the very law of Aliyasantana law, this system of law applicable to persons by Madras Aliyasantanam Act 1949 or by customary Aliyasantanam law, and regarding Marumakattayam Act, the law, this system is applicable to persons by Madras Marumakattayam Act of 1932 or to Travancore Acts and Cochin Acts. And regarding the last one, that is Namrudi law. So, the very system of law applicable to persons by Madras, Cochin and Travancore Acts, and these laws are applicable to such persons in Madras, Cochin, Travancore, and all those persons coming under these laws are also considered as Hindu, and they are governed under Hindu Succession Act 1956 regarding succession or inheritance to the property.